You know, at Tax Rep, we only accept sponsors of products we actually use. And the two items you need to run your practice is Tax Help Software and ENQ. Tax Help Software will enable you to automate your transcript downloads, calculate your statutes, the expiration dates accurately, look for penalty abatement opportunities, and complete the resolution program and forms efficiently and accurately. Just go to taxhelpsoftware.com and use promo code TAXREPTRIAL for a 2-week free trial. And when you love it and you want to buy it, use TAXREP10, all caps, one word, and save 10% off your purchase. Need to call the IRS? Use ENQ and shave a ton of time off your hold. And we all know the hold times with the IRS seem to just get worse and worse and worse. By using ENQ, you can get through to a human being and help your clients get their case resolved. You can try ENQ now, getting 200 minutes for $19.95. So for under $20, you'll get 200 minutes to try ENQ. And trust me, it'll change the way you deal with the IRS. Just go to callenq.com/TRN and never spend a lot of time on hold with the IRS ever again. With IRS cases surging, it's time to put the pedal to the metal and jack up your marketing efforts. If you want more clients and want to add that 100,000 to your bottom line and make 2021 the last tax season you ever have to work, then get out and grab your listing on Tax Rep Directory. Go to taxrepdirectory.com. It is where the real tax pros are all listed and where clients can find them. All right. Go to taxrepdirectory.com, claim your listing, build out your profile, and start bringing in more clients, increasing your bottom line today. So the phone rings from a prospective client who needs help. Now you need to close them. How do you do this? Right? And this was one of my biggest frustrations. We get so many, inquiries and then following up. Well, working with our friends at Rapid Funnel, we created the Tax Rep app. Okay. And what it will do is automate all of that for you. Okay, you will have IRS resources at your fingertips, the numbers you need, the IRS allowable standard tables. If you're meeting with clients, it'll all be right then and there. You can pull it up, show them, walk them through it, and get them closed. But for those people who have made an inquiry, instead of you having to follow up, the app will do it for you. We've built out a marketing drip campaign on everything from non-filers to audits, payroll taxes, innocent spouse case, offers and compromise, and just routine collection cases. And it will continue to follow up with that client where they can book their consult and even pay for the consultation right through the app. All right. So go to taxrepllc.com/app, use group code TRN, as in Tax Rep Network, set up the app, and watch this transform your practice.
All right, everyone. Listen, thanks for tuning in this week on Tax Rep to the Tax Rep Network podcast. I'm Eric Green. Joining me again is my friend Jason Freeman. If you're not familiar with Jason, he is a civil and criminal tax controversy attorney, does what I do in Frisco, Texas. He was on previously and covered community property issues for us, being in Texas, a community property state. We're going to talk about today the current status of international enforcement by the IRS, and he's actually got a conference coming up on the 18th, Jason.
Yeah, 18th and 19th.
18th and 19th. And so I will put a link to that down below for those of you who are interested in that. It's virtual. You can tune in from anywhere. Jason has got a huge lineup of the top people in the country talking about this. So I think it's going to be a great program. So Jason, listen, thanks for taking the time to do this. The truth is, I don't do a lot of international. It's just, we're in New Haven, Connecticut. It's just not a lot of what we get in the door. And I've started getting questions about, well, what happened to offshore? And what about Streamlined? Is that still around? And the delinquent procedures and all that. So I just thought it'd be great if you could take a little time. Do you mind updating everyone on kind of where we are right now?
Absolutely. So yes, they are around, somewhat modified form, and I'll kind of go through and give the lay of the land on those. But, Eric, it's it's been an interesting ride. Think over the last decade plus, where we've seen this kind of truly a revolution in international tax enforcement. And you kind of go back. It actually ties into the program, so I'll kind of give the listeners a little bit of the history. But you go back to that 08-09 period where you had you had the DOJ really going after sinking its claws into a number of Swiss banks, UBS being the poster child.
Right.
And there's an interesting story that's would take longer than the amount of time we've got for the podcast. But what you saw out of that was the IRS issuing a number of John Doe summonses, really going after about a dozen Swiss banks. And what results from this effort, and part of this effort was kind of springboarded by a whistleblower and some data leaks, but a whistleblower named Bradley Birkenfeld. And what you saw as a result of this effort was UBS ends up coming in, entering into a deferred prosecution agreement and back in the 08-09 time period. And as part of the deal, at least promises and publicly promises they're going to give, 4,000 or 5,000 names of U.S. taxpayers with undisclosed accounts. What the IRS did there is really leverage that kind of brilliantly, almost a brilliant marketing campaign, I guess. Leverage that to exert pressure on taxpayers, and basically said, look, we're moving forward with this. We are going to open up something known as the Offshore Voluntary Disclosure Program. There are a bunch of names that are about to come forward. If you're on those, it's too late. But if not, come in. We'll give you a good deal. We will give you criminal amnesty, and you'll be able to get back into the system and avoid criminal prosecution. And so what you really ended up seeing was, over almost the course of a decade, you had between that and an adjunct program, the streamlined compliance procedure, you had more than 100,000 taxpayers come forward and 11 billion plus in dollars coming in, plus criminal prosecutions.
Well, and remember, when that was all going on, I don't know about you, what we started getting, people coming into our office saying, I moved here 3 years ago. I left my accounts in Italy. Why am I giving the government, I think it was 20% initially, was the initial the penalty.
Yep.
Why am I giving up 20% of my life savings to the US government when I did nothing wrong? And so we're quiet disclosing everybody. And I remember Congress said they estimated nearly 250,000 people quiet disclosed. And why aren't you doing more about this, IRS? And I think that's what prompted the streamline. That if it's non-willful, whatever, 5% come in. Because I remember thinking that it seemed to be a complete, an absolute response to what do we do with people? And, it's not like we would never quiet disclose the criminals, but we had a ton, listen, I'm in New Haven, we're by Yale. We had tons of Indian and Chinese I had this Italian grandmother, people who just came here, left accounts back in the old country and didn't do anything wrong, or at least certainly nothing willful.
Yeah.
So
no, I tell you what, yeah. I mean, so it's amazing the fact patterns you would see out of this. Truly interesting stories like made to make movies. For example, like, I had several similar situations where the accounts were actually inherited, and the beneficiary who becomes a client doesn't even know about the account until after the voluntary disclosure program was initiated, right? But arguably, or in the law, they may have actually owned it or had beneficial rights in it. Even at the time, they didn't know about it. So obviously they couldn't couldn't have reported it correctly and had some potential exposure because it's always an evidentiary issue. Can I demonstrate they didn't actually know that back then? So yeah, it's a crazy area. It's still out there. So Eric, what you've got now, well, just to kind of go back, the program, you had the offshore voluntary disclosure program that morphed several times over the years. Then back in, I think it was 2014, you had the streamlined compliance procedure come into the picture, which, as you alluded to, was not for folks with willful violations, but for folks with non-willful violations. And it came with a lower penalty, for some, no penalty. And then you had kind of a procedure that the IRS adopted that was kind of known as the delinquent filing procedure, or delinquent international information return procedure, and delinquent FBAR procedure, which the idea behind those was you'll submit in accordance with this procedure, and you'll submit a reasonable cause statement, and the IRS would not automatically assert penalties. And so back in the dates all get jumbled, especially after the last year and a half, but back in late 2018, the IRS ended up formally closing the offshore voluntary disclosure program. But the offshore, or the voluntary disclosure practice of the IRS continues, and that's continued for decades, right? The offshore voluntary disclosure program was built upon this voluntary disclosure practice. And so that practice continues. And so in effect, there is a program, right, that covers both domestic and international. And there are definitely some international specific procedures as part of that program. Right. And so that continues on. The streamlined program, or filing procedure, continues on. It's still available, although there have been some overt and less overt threats out there that this would be at any given time, taken back by the IRS when it feels the population is adequately educated about the reporting obligations. So that continues, at least as of today. The delinquent filing procedure has morphed into something that, while it sure looks the same on a web page, or looks pretty similar, it's, I will say it has morphed into something that is kind of unrecognizable from what it was.
Yep.
What we see now is, going through that procedure will pretty much certainly result in, imposition of a penalty, with an opportunity to go through appeals and argue.
Well, I think that's the difference. Is the attitude now at the IRS is they're going to reverse. They're going to almost guaranteed hit you for the penalty, and then you're going to have the opportunity to argue out of it. Whereas before, you did this statement, and on a lot of these streamlines we never heard from the government. Again, there's no letter saying congrats, you're done. You just never heard from them. So for like 3 years, I kept this stuff active in my files, and we just would tell the client, look, we're going to close it. We've not heard from them. They cashed the checks a year and a half ago. I don't think we're hearing from them. But so I actually am on the subcommittee for voluntary disclosure, and I've had my two co-committee members, Laura Gavioli and John Nail, on the program with me. One of the criticisms I have, and we have, and we just actually submitted comments to the government, the new voluntary disclosure practice, they have this form, I think it's 14457, I think.
That's right.
They asked it used, so there was pre-clearance where, remember before, it was name, date of birth, social, and address. That's it. you just sent a fax over. The goal was to make sure you're not under investigation. The new form has added, give us the non-compliant bank information, like upfront.
Yeah.
And I sort of got into it a little bit with the IRS. Dan Price is the attorney out of, I think, Austin, who oversees. He and I kind of got into it a little bit. I said, why do you need that? Well, we need to know. I'm like, no, you don't. Pre-clearance is, do you know about me or not? Because if I'm already in investigation, I have a Fifth Amendment right. I may not want to disclose. And I don't understand why you need that up front all of a sudden. Because I got to tell you, I've had at least one client decide not to come in.
Mm-hmm.
If they have to disclose that up front, they'd rather not come in if the government hasn't found them now. And here's what happened. They're with one of these banks that cut a deal, but they were in a foreign country when they opened it. They've since come to America and gotten American citizenship, but the bank doesn't realize it. That's why the bank never turned over their information. So we ended up with this, ethically, I got to tell you, every single year now you have this issue. And their feeling was that they're going to quietly move it at some other point and they're going to bring it back in, because they said, if we hand it over, we know we're looking at, because it's one of those banks that there was a 50%, penalty on, because it was one of the ones that were criminally indicted. They said, why would I give up my half of my life savings when I am not a criminal?
Yeah.
And I understand that.
I too. Those are tough situations that kind of fit in the box of what the IRS thinks it's looking for, but it's the nuance there, right? I mean, I see the exact situation. They move to the U.S. Previously had opened the bank account at the so-called bad bank, and that's just not what I mean. That doesn't fit within what the IRS is purportedly looking for. I'll say I read your comments that were submitted. Actually, Laura Gavioli had sent them to me. I think fantastic work. Y'all been doing great work for a long time. And I know Dan, and actually, so Laura Gavioli and Dan Price will both be on a panel at the International Tax Symposium, and they'll be talking about voluntary disclosures. I'll tell you, I've had, Dan and I've known Dan for a long time. We've probably spoken on panels together on voluntary disclosures probably 20 times, and he and we're good friends, but we have many differences of opinion in terms of the best way to approach this program. What I always tell Dan is there's a number of issues. So one is this: for the IRS, I have found that they tend to believe this willfulness issue, this sort of threshold issue for whether this is the program or Streamlined is the program for you, is a real black and white issue. And as I'm sure you know, in our world, on this side of the V, it's always in the eye of the beholder. It's an evidentiary concept as well. And it's often ambiguous. And so then it becomes sort of a risk tolerance type question for a client, and what will help them sleep at night and get rid of that anxiety. And sometimes that's doing too much, right? But it's never sometimes it is, but it's often not a crystal clear issue. And then, the morphing of the pre-clearance process, which you're referring to, right. In the good old days, Eric, you probably remember, you could get a pre-clearance fax back from IRS CI in 24 to 48 hours. I mean, they were just boom.
Yeah, that was a long time ago.
It could be 6 months now.
Oh, listen, you're old enough too. Do you remember when you'd walk over to CI and find your friend and say, look, I got someone who wants to come in, and you'd negotiate in the parking lot, 3 years, 6 years. Oh, yeah. And it was a handshake deal. And then I would always send a letter saying, just to confirm, And you know, it was always, Eric, if the facts stand up as you told me, yep, come on in. And so I would negotiate for 3 years, not 6 years, and there'd be no penalties. And yeah, no, I mean, I do understand why the government didn't want that, because it's not a good process. It's not good policy if the deal you get depends on who you know.
Right.
And I get that. And so the initial pre-clearance made sense to me, because the goal, and I told Dan, the goal for you is to confirm that I'm not already under investigation. What do you need the bank account information for?
I agree.
Yeah, well, there's no reason for that, and it has a chilling effect on people coming in.
Yep. No, I think that the initial shift, I agree, that goes to uniformity, right? And that is I think that's a valid tax administration goal, and one that actually fosters compliance, right? But yeah, the shift that I think we've seen in the pre-clearance, chilling effect is the exact right word. And I've seen it, just like you have, a number of times where giving up that kind of information is not something a taxpayer is willing to do, where they were otherwise inclined to come in and make a voluntary disclosure and get compliant. And it's all a Fifth Amendment. I mean, it is all a Fifth Amendment issue. I mean, that was kind of the reason, frankly, for the pre-clearance process initially, is I've got a client, I don't want to have to waive Fifth Amendment privilege or my active production privilege with respect to, incriminating information until I have at least some baseline level of assurance that this is going to be a timely and otherwise acceptable voluntary disclosure. I mean, we can evaluate whether it meets all the other criteria. We can't evaluate whether it's timely,
right?
And so submitting it
for the audience, just for the audience, when Jason's talking about timely, you can't make a voluntary disclosure if the government already knows about you. Hence why when UBS came forward and turned over those 4,400 names or 4,500, whatever it was, names, it was too late for those people to come in. So the question is, how do you know if the government knows about you or doesn't know about you? You had this pre-clearance where you could go in, name, social, date of birth, and address, so that the government made sure they knew which Eric Green, let's say, they were talking about, and they would come back and say, you're cleared to come in, meaning you're not already under investigation. You're not under civil or criminal audit. We don't know about you, so come in. And you didn't have to disclose anything. Now it's sort of like they almost want you to do the disclosure, and then they'll decide if you're timely or not, which is, to me, a problem. Dan doesn't see it as a problem.
Yeah, but it does. I mean, it's probably anecdotal for us to see the chilling effect, but you imagine that you multiply that across the several thousand practitioners that we probably know dealing with the same issues, and it's a large number. And that's where my thought on this is not so much just from an advocate's perspective. It's more from a global tax administration perspective. I'm not sure I agree that process is best effectuates what they're trying to do. Right. And for us, it has an effect, because we otherwise have an avenue to largely absolve a client of exposure.
And it's a real problem, because quiet disclosure doesn't work. The government will know electronically in an instant, right? If you suddenly start filing, online back FBARs, I can't imagine that they won't know, right? I mean, yeah. You have to say, if it's late, why are you filing it late? So if you don't come forward, let's say the client says, well, I'm not coming forward, the non-compliance is going to have to, I suppose theoretically you could just start from here going forward and hope it doesn't get flagged. But I don't think you can, I don't know, but I love your opinion. I don't think quiet disclosure works anymore. And I mean, the software and all that, it's simply too good. So you're left with the choice of, do I fix it now going forward and hope they don't pick up on it, or I'm not going to fix it, which means the non-compliance continues.
Right. Agree. I mean, that's been part of the shift in electronic filing, which is now essentially the default mechanism for filing. And the IRS's systems, which, let's be frank, have historically not been all that impressive, have improved drastically in recent years. And so the ability to match is, maybe it's not instantaneous, but it is, it's quick.
They'll have the data.
The data is there. The data is there. Whether the manpower is or not, depends on Congress, I guess, over the years. But the data's there. The link, you're right. For most situations, the quiet disclosure is probably not what it used to be.
No, it's well, and here's the other thing. I think the government has lost sight of what is the goal of voluntary disclosure. It's to get people in the shadows into the system. All right. The government seems to have shifted to, this is a way for us to punish people. And I think that the great thing about the initial offshore and then the streamlined and the delinquent foreign forms procedure was, just come in. We want you in. I mean, the goal is, we want you to comply. Even offshore, no penalty if you live in another country. Just come into the system. And now it seems like there's a different attitude of, we'll let you in, but you're going to have to pay.
You hit the nail on the head, man. I mean, you did.
Yeah.
That's it. And the problem with that is there's multiple problems, but the problem with that is our system is fundamentally based on voluntary compliance. I mean, 99% of the taxes we collect come directly from voluntary compliance. And so you've got to get taxpayers into the system voluntarily compliant, because we don't have, the IRS, does not have the resources to go after all the non-compliant.
The amount of collections from enforcement efforts is about 50 billion. It is a fraction of our total, what, $3 trillion top line. I mean, the government cannot possibly enforce its way out of anything. And so let's be honest, voluntary compliance costs a fraction of what enforcement costs. So if we can get people into the system, by the way, the state of Connecticut is the same way. We had a great voluntary disclosure program that they continue to just try to make as miserable as possible for people in the hope we don't come forward. But the goal, I think, though, is you want people voluntarily filing their return and paying their taxes. You and I make a lot of money because there are a lot of people that don't do that. But if I were the government, I would not be throwing up roadblocks for voluntary disclosure.
I agree. I think you want to invite them in. I mean, you want to invite them in because each of those taxpayers who comes in, they're going to be some of the most compliant taxpayers in the years to come, because they don't want to screw up what they've achieved. The other reason, Eric, that it's kind of problematic is, you look back at the legislative history behind most penalty provisions, perhaps other than fraud, but penalty provisions, and you look at the IRS's actual formal pronouncements of the purpose of penalties, and they are to promote voluntary compliance. They're not to punish.
Right.
And so to kind of then use them as a hammer hanging over the taxpayer
After you've come in.
Yeah, exactly. After you've achieved the purpose that they were designed to achieve, to then use them sort of gratuitously to extract your pound of flesh is contrary to, I think, the reason they exist in the first place. But yeah, I mean, I think it's easy to lose sight of that, and especially, I mean, just to kind of put it in perspective from their angle, a lot has happened over the last 10 years, and I think from the government side or many side over there, it's kind of the sense that everybody now kind of fully understands what they need to report, and has this sort of day-to-day awareness about it. And just the reality is people don't. There's still a lot of lack of education. You see it among taxpayers. I mean, I would put it at easily less than 10%, maybe less than 5% of well-educated tax preparers who have much of a command of the international tax filing obligations.
Right. No, I mean, look, I think we're both on the same page. Hopefully those comments get some traction at the government. And there were a lot of good comments in there, but to me, the biggest was this pre-clearance issue with the banking information. I just don't understand why the government suddenly needs it to know if I'm under investigation or not. But we'll see. Dan doesn't agree with me, so we'll find out. See whose opinion carries the day. But
Dan has not agreed with me on a few things, and he's gotten a few submissions from our office on policy issues. I'll give it to his credit; he does always listen. He explains. I've seen him.
By the way, great guy. I mean, we're having him on the New England Rep Conference. Same thing. I mean, he's a good guy, and I don't want to paint him as some sort of ogre, but I figured that. I thought that the banking and the pre-clearance would sort of be a no-brainer. In fact, I didn't understand why the government put it there. But you talk to him, and he's like, "Oh no, we need that." I'm like, "Why?" I'm not buying that. But okay.
No, he really is a phenomenal guy, and some of it is from our perspective, who knows, because there's more than one person over there giving input, and so he certainly does his job in justifying it, and whatever his personal beliefs ever may be. But I would say he certainly, I think, looks at things critically and takes the policy considerations up. And, I'm very appreciative of him and think he's done a good job, but definitely have some differences of opinion on a few of the issues.
Right. And listen, by the way, the last thing I want to touch on, because time is short, the delinquent foreign forms, whereas before it was, look, just file them, right? Just file them and let us know you're doing it pursuant to the delinquent international forms procedure, and there's no penalty. Now, it's flipped, right? In other words, when you do that now, they're going to hit you for the penalty, and then you're going to have to argue out of it.
Yeah.
Again, it's another chilling thing, because so clients can start adding up what the penalties are going to be. And, if especially like the 35, the inheritance, it's a percentage of what you inherited when there's no tax due. Yeah.
It's crazy. Some of these penalties are truly draconian. I mean, some situations they raise Eighth Amendment issues, unreasonable fines, but the delinquent filing procedures, I mean, I think you've got to question whether they make any sense from a practitioner perspective, because at this point you are inviting an automatic assessment.
Right.
You can give them a peek at your reasonable cause statement, I guess, but I'm not sure that does a lot of practical good.
I mean, and just, let's wrap up with ethically, the client comes to you and say, "What do I do?" I think I'd walk them through it, say, "Look, here's the government's position on this. The options are you do just that, right? We submit them, we do the reasonable cause. You're just, you're getting the penalty, you're going to hit the penalties. This is roughly what it's going to be. And then we'd have to argue for reasonable cause and hope that we can get to an appeals officer that's reasonable. 2, you just start filing going forward and hope they may not pick up on it. Or 3, you do nothing. Like the 3520, after you got the inheritance. I mean, I got this. Somebody said I never filed it. I said, how long ago? 11 years ago. I'm like, look, if you go in, and I mean, I think ethically, I have to tell you, look, there's no statute of limitations. You should file it. The penalty, 35%, whatever. And they were like, I don't want to do that. And I'm like, well, then your option is do nothing. Whether it'll come up or not, I don't know. But I got to tell you, I don't know what the downside is.
Yeah.
You always have the reasonable cause argument. So, I mean, I don't know if I could advise a client to do this. Is a good ethic. I should get Karen Hawkins to tell me, answer this. I don't know if there's an ethical issue where I could tell people, but I can tell you right now, if it were me, I ain't filing them.
Yeah, well, just from take the ethical part of it out, right? Yeah. Which is ultimately what most clients are considering, what's in their best interest. I can either go forward, put this on their radar, and be assured of an automatic penalty, in which I have to argue, or I can play the audit lottery, essentially, which are, the odds are in the taxpayer's favor. And then submit my reasonable cause statement later if the IRS chooses to unilaterally go back 10 plus years or whatever situation is. I mean, I think most clients are going to choose exactly that option. For us, yes, it does present a tightrope to walk, I guess, from an ethical perspective. But the reality is the Supreme Court, as you know, has said on a number of occasions, amended returns aren't required or not legally required. Taxpayer, once that deadline is passed, it's a different situation than advising them prospectively for what they need to do. I think you present them with the options, you educate them, which is part of our ethical duty, to educate them about the various options. And then ultimately it's the client's call. Ultimately it's the client's call.
Yeah, no, I agree. And listen, thanks for taking the time. I'm happy we could just update people on this. For those of you who are interested, the 18th and 19th, it's November 18th and 19th. So in a few weeks, Jason's got his International Tax Symposium going on. It is virtual. You can get it from anywhere. I'm going to put a link in the description below. No, Jason, listen, thanks for taking the time.
Yep, I appreciate it. And best of luck with your conference. I'll be watching, though. I'll be in after the fact, but have been a huge fan over the years.
Hopefully next year we're back in person. It's a lot more fun when we're all together. But hopefully the virus becomes endemic. It just fades into the background like the flu, and we get back to normal.
We can hope.
One can hope. But all right, listen. Thank you.
Thank you as well. Thanks for having me, Eric.